Hello and welcome to today's session of Atma Network Webinar Series. In keeping with our efforts to help NGOs, the Atma Network uses this webinar series as a platform through which subject matter experts help organizations with best practices so you can manage your NGOs more effectively and impactfully. And today, we are going to address a topic chosen through popular demand, FCRA. Yes, the Foreign Contribution Regulation Act. And to enlighten us about this very essential topic, we have two very experienced and enterprising speakers with us, Sunil Goel and Dhaval Kodilkar, who are both from the firm Sunil Goel Associates. Suhel is a senior partner at the firm. He is a fellow chartered accountant and an expert on cross-border transactions and foreign investments. He also advises NGOs on FEMA and FCRA matters and on structuring of organizations from a complexity compliance focus. Dhaval oversees the firm's Mumbai operations and is also a taxation and an FCRA expert. His portfolio consists of a number of local NGOs, including existing partners from the Atma network. But before we begin, let's recap a few basic rules. All attendees are requested to stay in the listen-only mode. Please mute your microphones so we can minimize any audio disturbances. Any questions you may have will be taken up in our Q&A section towards the end of the webinar. So please type your questions in the chat box that you see on your screen. And do keep the questions coming. A topic like FCRA will be better understood if attendees raise specific challenges that you or your organization is facing pertaining to this registration. And last but not the least, after the session, we will mail all attendees the presentation that you will see today and any other additional resources relevant to the topic. So, well, that's it from me. Over to you, Suhel. Welcome.
Thank you, Gitika. That was a very wonderful insight into the whole purpose in which we're here today for the presentation. Before I begin, I just wanted to check with everyone if they can hear me clearly, if they'd like for me to speak a little slower, or if I'm comprehensible, I can proceed. And also, if you can see the opening slide of the presentation at your screens, if you can just comment in the chat box and then I can proceed. Okay, great. So I think most of you can hear and see the presentation as well. At the outset, thank you for Atma arranging this network webinar series. And we've done this in the past as well. And we've realized that there has been a lot of use for a lot of the NGO partners of the Atma network with the different topics which are covered in the series. And there have been instances where a lot of hotly debated topics are discussed and a lot of insight sharing along with the Q&A, which forms the backbone of any presentation. In today's presentation, the way we're structured is that we're going to try and keep the formal presentation to between 30 and 35 minutes, allowing for about 20 minutes as a bare minimum for the Q&A. We would strongly request that you can put in your questions while we're presenting in the chat box, and my colleague will be separately marking those for addressing at the end of the presentation. So feel free to have the questions coming as we're presenting, and we'll try our best to address a fair majority of them towards the end. And if there is anything which is missing, we will separately try and address those offline as well. Let me begin the presentation with the objective with which we're all assembled here. FCRA tends to be one of the most misunderstood, as well as a topic which requires a lot of deep understanding, but tends to be ignored by most professionals, as well as other people which are managing the finance and the compliance piece of the work. Typically today, what we're going to be trying and doing as a quick overview is to introduce the compliances and the various reporting requirements under the Foreign Contribution Regulation Act of 2010, referred to in today's presentation as the FCRA Act. We will also try and touch upon the eligibility as well as the registration requirements for people who are looking for a permanent registration, as well as people who are looking for a prior permission. We would also try and touch upon the associated compliances and the regulations which are affecting the FCRA provisions, and also the recent developments which have come about in the legislation, as well as some practical topics which we'd like for you to be aware of. Uh, it's an interesting question that why foreign funding was brought about and what was the reason that non-profit organizations, which play a very crucial role in sort of working towards the upliftment of the weaker sections, as well as to work in the major sectors of the country, such as health, education, etc. In the past, what typically happened was that philanthropy was not a topic which was given a lot of emphasis by both individuals as well as businesses till the very recent past, uh, basically necessitating the non-profit organizations to look beyond the domestic frontiers, and therefore they had to tap into the foreign pool of funding and contributions, and then eventually that led to the creation of a regulation in 1976, which was subsequently amended in the year 2010. In today's presentation, the agenda would basically have the introduction bit that we'd run through very quickly, followed by a few of the other bits that are visible on your screens. Again, as I mentioned, we'll try and keep sufficient time for the Q&A portion, and you can have your questions addressed at that point of time. As a matter of introduction, way back in the year 1969, the Home Ministry raised the issue of regulating of the foreign funds. This was with a combination of factors, which meant there was a huge amount of foreign inflow which is coming through. It could have affected the functioning of the government, the political parties, as well as affected the security and stability of the country as a whole. For the next 10 to 20 years, it took a while to have the law enacted, which it was done in the year 1976. There were subsequent amendments being carried out from time to time. However, with a passage of nearly 25 years of existence, there was a need in the early and mid 2000s to amend the Act, and it was first proposed in the year 2006, which underwent, like any other piece of statute, several rounds of discussions, as well as suggestions from the relevant stakeholders. And finally, in the year 2009, there was the bill which was passed, and the Act came into existence from 2010, but notified from the year April of 2011. So that's like a historical perspective on the different provisions and the statute in place. This has also subsequently been amended by the Amendment Rules of 2015, as well as the most recent notification of March 2019, further amending the contribution rules, which are the guidelines under which any non-profit organization has to operate in compliance with the FCRA provisions. We wanted to spend a couple of minutes for you to understand what are the key definitions and what are the key bits for you to understand before going into the technical bits. At the outset, foreign contribution as a terminology that needs to be understood to be able to decide if there is an applicability of the FCRA provisions. Under Section 2, the foreign contribution is defined, which includes any donation, delivery, or transfer made by a foreign source of any article, currency, whether Indian or foreign, security, as well as an income generated from a foreign contribution originally received. And it does exclude any fee, which means including a fee charged by an education institution, as well as amounts which are in lieu of goods and services. So what we'd like to basically say here is that wherever there is a quid pro quo kind of situation, wherein if a money is received under a reciprocal obligation of the Indian entity to perform some services or provide some goods, that will never be classified as a foreign contribution. So as a simple example, if as a professional, there is a grant which is received from overseas, but that professional is obliged to perform a certain set of services in lieu of receiving that money, that will not be covered under a foreign contribution. On the flip side, if there is a grant which is received by a non-profit organization where they are allowed to use that money for any of the purposes for which they're incorporated, and assuming this is from a foreign source, that would mean that that does get classified under a foreign contribution. Moving on, a foreign source is another terminology that you need to be aware of. While some things are fairly obvious, which means the government of a foreign country or any agency of a foreign country is classified as a foreign source. Similarly, there are some international agencies which are not within the umbrella of the UN, the World Bank, IMF, etc. They would be also classified as a foreign source. A foreign company, excluding certain exceptions, by and large would always be a foreign source. And similarly, a corporation incorporated in a foreign company, a MNC, would always be a foreign source. Another thing which is important to keep in mind is the citizenship of the donor of money. There appears to always be a confusion if a foreigner, which means a foreign citizen, is giving money in Indian rupees to a non-profit in India, whether that would also be classified as a foreign contribution. The answer is yes. You need to basically see the color of the passport of the individual, and as soon as that is not the Indian passport, even money received within India in rupees would also be classified as being received from a foreign source. There was a recent amendment in the definition of the foreign source. This was done in the Finance Act 2016 with retrospective effect from 1976. The quick background of this is that the Delhi High Court, hearing a public interest litigation, had passed certain strictures under which the political parties of the country, which had received monies from foreign companies having subsidiaries in India, they were affected by the FCRA provisions. And therefore, to mitigate the impact of the Delhi High Court judgment, the law was retrospectively amended. And it said that if for an Indian company where more than 1/2 of the nominal value of the share capital is held by a foreign company, and that's the portion highlighted in yellow, to repeat, where an Indian company where more than 1/2 of the nominal capital is held by a foreign company, and the Indian entity is in compliance with the foreign exchange laws and the guidelines put in place by the Reserve Bank of India. In this situation, such an Indian company will no longer be classified as a foreign source. To spend a minute on this further, an Indian company, like say XYZ Private Limited, which if it was owned 51% by a foreign company, before this amendment, even the Indian company was classified as a foreign source. But now with the amendment, even if 51% is held by a foreign company, but the holding in India is in compliance with the FEMA provisions as well as the RBI guidelines, then the Indian company will not be treated as a foreign source, and any grants being made by the Indian company onwards to any non-profit organization would automatically also not be classified as a foreign source. So in essence, what we're trying to suggest is that you must keep in track whenever you're receiving any money from any of the Indian companies, some details about their ownership to understand whether they are compliant with the FEMA provisions. Otherwise, you might be in a situation because of ignorance. A foreign source may wrongly be ignored for the purposes of treating them as of FCRA required grant. Moving on to the basic questions that we're trying to address today, the requirements for registration and prior permission. I'm sure you understand there is a significant difference between an entity which is registered, which means it has permanent registration under the FCRA, while an entity which is seeking a prior permission, and by prior permission, there is a restriction in terms of receiving the money from a specific donor of a specific amount of money for a specific purpose. So prior permission is fairly limited in its ambit of applicability, while a registration is a blanket registration. When we're looking to decide what route you might take, the first and foremost thing is you need to be sure if the organization has been in existence for 3 years or less. In case you're registered for more than 3 years, you are allowed to approach the Ministry of Home Affairs for seeking a registration. If assuming that you're receiving money from multiple recipients and multiple grants, that's the route of permanent and a blanket registration that you ought to take. While in case you feel that it's a one-time grant and you do not want to be covered under the complexities of a permanent registration, you can apply and take a simpler prior permission route. In case you're not in existence for 3 years, then the only option you have is to go for a prior permission route, in which if the foreign contribution sought to be received is more than 50 lakh rupees, you will be subjected to closer scrutiny with requirements of submission of 3 years of accounts and activities, while if the amount is less than 50 lakhs, the process is slightly simpler, which we will touch upon in the next few slides. For the registration bit, the condition, as we mentioned earlier, it can only be for associations which have a definite cultural, economic, educational, religious, or a social program. They must be registered organizations, which means you either need to be a registered trust, a registered society, or a registered Section 8 company under the Companies Act 2013. You also need to submit the activity and report and the audited accounts for the last 3 years, duly highlighting the different activities that you would have done and the spending of money at different sources. One of the other bits which is normally recommended is also that you ought to have spent at least 10 lakh rupees across the last 3 years on your core activities and not on the incidental or the administrative tasks. To repeat, you need to have 10 lakh rupees spent on your programs, excluding any other expenditure which is towards the administrative expenses. This appears to be one of the most common reasons for the Ministry of Home Affairs to reject an application, even though this has not been notified under law. But this is something that we always advise our clients, and based on practical experiences, we've seen cases being rejected only because of non-compliance with the spending requirements. In case we're going through prior permission route, again, as I mentioned, you must be a registered organization, a trust society, or a Section 8 company. You must have a commitment letter from the donor clearly specifying the amount of foreign contribution and the purpose for which it is to be utilized. You must submit a project plan, clearly identifying what is the benefit for the public and how the money will be used. As I mentioned earlier, if the proposed foreign contribution is more than 50 lakh rupees, you must enclose the audited accounts as well as the activity report for the last 3 years. There was also an amendment which was brought about in the procedural side with the new FCRA Act of 2010 and the subsequent rules. Under the erstwhile 1976 Act, the registration was permanent for eternity, but under the new provisions, a registration is valid only for a period of 5 years. After every 5 years, you need to go in for a process of renewal. So for example, if you were originally registered under the Act in 2011, you ought to have renewed your registration by 2016, and then subsequently in the year 2021. For the renewal process, the application should typically be made at least 6 months before the expiry of the certificate. This is because the Ministry of Home Affairs does carry out an extensive insight into your activities. It does evaluate what you've done, what you've not done, and they do take at least 6 months in processing the application. And we would strongly advise for you to err on the side of caution rather than delaying it till the last date. In terms of the documentation, it's fairly simple and straightforward. You do need to provide the registration certificate, the charter documents, as well as copy of the FCRA registration certificates, which ought to be renewed. Moving on to the next part of the presentation, which are the different compliances and the obligations to report to the Ministry of Home Affairs. For your convenience, we've made this into a tabular presentation where you can understand the different reporting requirements as the applicable form. Just to let you know the key important ones, whenever you're applying for FCRA registration, you need to apply under the form FC3A. For a prior permission, the form is the FC3B. And for the renewal, it's form FC3C. What you also have to keep in mind that there is an annual filing which needs to be done within the 9 months of the close of the financial year, which means by the 31st of December, the form FC4 needs to be filed, which is the annual return. In case you're looking to transfer any money or foreign contribution to another unregistered entity, you need to file a form FC5 seeking prior permission before transferring such a contribution. Another important aspect which you need to keep in mind is the intimation of the quarterly receipt of foreign contributions, which needs to be done online within 15 days from the end of each of the respective quarters. Important bits which you need to keep in mind for changes in the governing structure, the name, etc., is the relevant forms that we've highlighted here. If there is a change in the name or the address, form FC6A, if there are changes in the nature, objects, etc. In addition to all those compliances which you need to be doing with the charity commissioner as well as with the tax authorities, you do also need to intimate the Ministry of Home Affairs in form FC6B. If there is a change in the designated FC bank, you do need to seek the appropriate intimation and permissions from the Ministry of Home Affairs with the relevant forms, as well as certain other changes which need to be intimated in terms of change of key members, etc., in the relevant forms that we've indicated on this presentation. Quickly moving on to some of the bits that we like for you to be aware of, the do's and do nots, as we'd like to term it. Quite obviously in the do's, this is stemming out from what we discussed slightly earlier. You do need to have definite purposes for which, or definite programs for which you've been incorporated and registered. You do need to undertake reasonable activity, and you cannot be performing an activity which is significantly different for the main purpose for which you've sought the foreign contribution. An important bit is for the purpose of compliance with Section 19 of the FCRA Act, you do need to maintain a separate set of books and accounts exclusively for the foreign contribution received. By this, we mean that you need to have effectively two sets of accounts, one which is a consolidated set of accounts having both foreign contribution as well as non-foreign contribution receipts and expenditure, while a separate set which is only considering the foreign contribution and the relevant expenditure which has been made out of that. You need to receive the foreign contribution only in the designated bank account. You cannot be receiving it in any bank of your choice. You do have the ability to have certain utilization accounts being opened in different branches across the country, but that should be done with proper intimations to the ministry as required under Section 17. And again, as we mentioned, you do need to file the regular returns and make the intimations which we discussed in the previous slide. And finally, you do need to have your accounts and the relevant records stored for a minimum period of 6 years. Some of the key do nots, which we would strongly like to highlight, and the first is the most important, where we've seen a lot of nonprofit organizations not keeping a proper track of how they're spending the money, and there is often a mixture of the foreign contributions with local grants, and there is no clear trail as to how the monies were received and how they were eventually spent. This is an absolute unpardonable offense. This can lead to severe penalties as well as potentially cancellation of the registration. And we would strongly urge for you to have the right financial structures and controls in place to ensure that there is no intermingling of the domestic and the foreign contributions. As we also mentioned earlier, you ought not to transfer any foreign contribution monies to unregistered organizations, as well as investing in speculative instruments in the stock market as well as mutual funds. You also need to be careful that you're not using more than 50% of your foreign contribution towards administrative tasks. Um, in essence, what we're trying to say is that you need to make sure that you have transparent records as well as utilization of the foreign contribution, and at no circumstance should you be hiding any of the amounts received or the application of such monies. Moving towards the last bit of the presentation, we do want to highlight for your reference certain stringent actions which have been taken by the Ministry of Home Affairs in the recent past. I'm sure a lot of you have been seeing these newspaper headlines. There appears to be sort of a negative perception about the compliance requirements under the FCRA. These tended to have been ignored for the longest time simply because the government was not enforcing the law as they ought to have done in the past. There have been actions which have been taken against several large foundations and organizations where they've been show-caused with different issues for non-compliances. Just some of these things that we wanted to bring to your attention. The Ministry of Home Affairs did send show cause notices to several small and large organizations for not filing their annual income and expenditure statements for a period up to 6 years. This was relevant for the years 2011 to March 2012, up to the year ending March 2017. This was the period which was immediately affected by the introduction of the new act, the Foreign Contribution Act of 2010. The ministry had been advising through several press releases, notification and advisories that you ought to be filing your returns within time. And finally, the ministry did warn that if the appropriate return filing was not done by the December of 2018, stringent actions were going to be taken. And as a result, several organizations have been removed from the database of the FCRA for inactivity as well as non-filing of the returns. Also, on the flip side, the government was also proactive in ensuring that the NGOs were keeping their banks with those specified scheduled banks which were integrated with the Public Financial Management System, the PFMS. This was a recent requirement which came through and caught a lot of the smaller NGOs or those which are operating in the not so large metro cities of the country, and they might be in the far-flung areas of the country, not having access to the right banks in compliance with the PFMS requirements. There were notices which were issued to several such non-profit organizations, but eventually, once compliance was done, the ministry did withdraw the notices and is being lenient on them, provided the organizations are in compliance with the requirements. Another notice was served in the month of April 2018 to those organizations which did not submit the annual report and accounts electronically. Yet, once eventually this was done, the ministry did come out with a clarification that the associations are strictly directed to explain why such show cause notices shouldn't be acted upon. And thereafter, the ministry did take actions in terms of either cancellation of the registrations or giving some reasonable time for the associations to explain their position. Again, what we're trying to suggest is that you need to be aware of the reporting requirements. You ought not to be in a position where you're served with such show cause notices. And in case there is actually such a situation, it's best to go with clean, open hands to the government. Either you seek a condonation of the delay in filing, or else you can potentially compound the offenses which you might have committed ignorant of the law. And the ministry does tend to take a lenient position, provided you've gone with clean hands and explained the entire position to the ministry in advance. Also, I mean, there tends to be a sort of a negative perception about the last few years, where the change in the government, I would rather term it as the compliance with the FCRA has significantly increased from the government's point of view. What they're intending to be doing is to ensure that the law of the land is being strictly implemented, and the previous governments, which might have been lax for whatever reasons in not implementing the law of the land, there has been a significant change in the current disposition, where there have been over 13,000 non-profit organizations which have either got their registration cancelled or some other significant action has been taken against them. In the year 2017 alone, nearly 5,000 non-profit organizations lost their licenses, while several of the others have also faced some action or the other, and the most notable out of them would obviously be the Ford Foundation and the Amnesty. And there is the ongoing proceedings which are still on in the relevant forums against such organizations. In conclusion, what we try and say is that you must err on the side of caution. FCRA tends to be one of those misunderstood provisions where most people tend to be ignorant, and in spite of the fact that the law is explicit about the reporting as well as its coverage, people tend to ignore, resulting in situations where they're non-compliant, and as a result, they are debarred from getting access to foreign contributions. At the end, we've tried to keep to the time. We're happy to take questions. We're happy to address any bit to people who would have wanted to have specific things being addressed. I'll open up the floor to my colleague Dhaval, who's been online as well, and possibly Geetika, if you can also be part of the conversation, and we can take up the questions. While my colleagues come online, I'm just taking some of the questions which I can see. I see a question from Meghna where she says that for FCRA, is it a requirement that the NGO needs to use a separate bank account? Yes, as we did indicate earlier, there is a specific requirement that the non-profit organization must have a designated foreign contribution bank account in which it receives the foreign contribution. For the purposes of utilization, you do have the ability to have several bank accounts, but all of those need to be pre-intimated to the ministry and duly reflected in your accounts for reconciliation and for reporting. Dhaval, would you like to take that question?
Yeah. So the next question is there whether through crowdfunding, so even for the crowdfunding, whether the power permission of the FCRA is required or not. So basically, for any funding, whether it's through a prior permission route or through a proper registration route, if your NGO is supposed to receive any foreign funds, you need to get a permission from the FCRA wing. So Garima, the turnaround time can vary between 6 months to 1 year. It is based on the how soon your application has been taken up by the FCRA wing. But again, that is subject to the other delays which may or may not happen at the office of the FCRA wing. So generally, the turnaround time should be between 6 months to 1 year. Yeah, Mercy, I would recommend that you should upload your quarterly reports at the earliest on the either your own website or on the FCRA website, and do that compliance as soon as possible.
Dhaval, I'll take that question. Basically, what you're trying to suggest, as I understand, is that if for a prior permission you received for about, let's say, 100,000 rupees, you've only spent 90,000 rupees. My understanding is for the balance, you're looking to apply for a separate FCRA number. Uh, I mean, there are two aspects of the question. Are you trying to suggest that a separate FCRA number for the balance, or you're saying that the balance will be returned to the original donor, which is the most likely option, and thereafter you can proceed to take a separate FCRA number? These are both with the understanding and assumption that you're not qualified to be registered as a blanket registration, and therefore the unutilized amount cannot be used for other purposes than what the prior permission allowed you to.
Yeah, so Nisha, in respect of crowdfunding, if your donors are not specific, then there will be a problem in obtaining a prior permission, because one of the conditions or one of the documents that you are supposed to provide with the prior permission application is a confirmed donor letter, that there is the commitment from a donor of X amount. So you will need to have that donor letter.
Dhaval, just to add one more point, again, in our past experience, we've also been asked this query that eventually it's the crowdfunding platform which is transferring the money. Whether the prior permission should mention the crowdfunding platform as the donor or the donors behind the crowdfunding platform. Unfortunately, the ministry has not clarified this in any manner. There have been occasions where the crowdfunding platform itself is treated as the donor, while on the flip side, at times when the crowdfunding platform is located in India, but it does allow for anyone from anywhere in the world to transfer money. In those situations, we normally advise clients to have details of the donors on the crowdfunding platforms to be available with them, and strictly reject those which are not Indian citizens to transfer money through the crowdfunding platform. Again, Nishad, I think we answered your question, so we're moving on to the next, again, follow-up of Garima.
So, Garima, if you guys have received any foreign contribution from a foreign national, and you have returned as well that amount, so I guess there shouldn't be any repercussion. But at the first place, the receipt of foreign contribution without having a valid FCRA registration is itself a non-compliance under FCRA. Irfan, there is no published specific format for the commitment letter for the FCRA application. but it should generally contain the objects for which the donations have been given to the NGO, as well as the specific amount which are committed by the donor. So those are the main things that should be there on your commitment letter.
To address this question once again, there is no monthly cash withdrawal limit from FCRA account. You can withdraw whatever you'd like, provided it's for the relevant purposes for which you've got the registration or the prior permission. No, that's a question which needs to be separately examined, because we need to understand what is the membership fee in terms of what is the constitution of your organization. When we mentioned right at the beginning, if the membership fee does not give any reciprocal obligations, potentially it might covered under the definition of foreign contribution. But we definitely like to examine this separately, considering the scale and the amount of such membership fee which you might be receiving, and whether this should be classified. So if you can possibly connect with us separately, we'd be happy to understand in more detail and advise you accordingly. Rohit, typically both the applications are sort of mutually exclusive. The provisions state that in case you've got an application which has already been filed, uh, should not overlap another application. There is typically a cooling off period of 6 months, and accordingly, it may not be advisable to file a separate prior permission application while one is under progress. Ram, as you correctly mentioned, you will need to either return the money of the unutilized portion or continue to use it for the relevant purposes. I understand what you're trying to suggest is that for the unutilized amount under prior permission, you don't necessarily need to utilize this first before applying for the registration under the foreign contribution, as long as the donor doesn't define a period in which you need to utilize the money. These are again two independent things, and while you continue to have unutilized prior permission amounts, you could still go ahead and apply for registration, provided the conditions are being satisfied by your organization.
Aditya, the normal banking channels are basically you have received that amount in your bank account. Let's say
Basically,
NEFT,
yeah,
through NEFT or to RTGS or an ECS or a check deposit.
essentially, Aditya, what the ministry is trying to suggest is that you shouldn't be getting transactions in cash or in, let's say, foreign currency, travelers' checks, etc., which are not possible to keep a track of in terms of their antecedents.
So, Vaidhi, to answer your question, the mandatory information that we need to collect from the foreign donors are basically their exact details, the funds that they're giving to your NGO, as well as the objects or the purpose for which they are providing those funds to you. Those are the one of the preliminary information that you need to collect.
And again, Dhaval, just to add, obviously, you need to be aware of the citizenship of the individuals, and in case they are foreigners, actually, so be aware of their particulars in terms of address, in terms of their tax registration number, etc. Anything and everything which will allow for you to justify that the source is a genuine identifiable source, and whether it is an Indian citizen or a foreign citizen.
So Shilpa, even if the foreign citizen who must have obtained a PAN in India, still any donations received from such foreign citizen will always be considered as the foreign contributions.
Garima, that would be hard to assess. It's a very fact-specific situation. If this is a genuine mistake or an overlook, the ministry might take a lenient view, but there is no clear yes or no in terms of applicability of a penalty. Obviously, a pure and simple reading of the law would suggest so, but in our practical experience, if you've taken the necessary steps to mitigate the oversight and error, the ministry shouldn't go ahead and levy a penalty. Sonu, we continue to maintain our stand that it would be best to discuss this question offline. Rohit, again, I appreciate it might be a frustrating process, and in those rare occasions, even in our experience, we have seen applications which have taken longer than the normal 6 months to 12 months period that we've seen. What we normally advise is that if you're located in New Delhi, you can seek an appointment with the Director FCRA through the Ministry of Home Affairs office. Try and visit the office to try get a little more detail. Normally on telephone, you don't get the right updates, but a physical meeting with the Director FCRA might be a better option, or you might send an email requesting for some inputs. There is no official way to speed up the application. Unfortunately, one has to respect the due process that the ministry might take. You might only be in a position to understand a gap or understand some missing requirements by trying to visit the ministry office in New Delhi. Aditya, again, what is essential is that the citizenship of the individual be considered. We once again like to reiterate it's the color of your passport which will typically decide whether it gets covered under a foreign source or not. The receiving of money in Indian or foreign currency is not the decision maker for being classified as foreign contribution or a foreign source. Irfan, the question is not explicitly clear. We assume that you're trying to suggest is transferring of some monies from the FCRA registered to a non-FCRA registered organization. As we suggested earlier, this is strictly subject to a prior permission and intimation with the ministry. You cannot transfer monies to a non-FCRA registered organization from an FCRA without following the relevant filing and approvals which are mentioned in our earlier presentation, in the earlier slides of the presentation. Dhaval, would you like to take that?
So, Aparajita, even if an NRI, even if he has an Indian bank account, but if he's an Indian citizen and if he makes a donation to you, so it depends. If it's from an Indian bank account, it will be considered as an Indian donation if it's an Indian citizen.
And just to complete, I mean, basically, as we reiterate, if it's an Indian citizen, wherever and however that person might be giving money, it would still not be classified as a foreign contribution from a foreign source.
So, Nisha, yes, you cannot transfer the funds from an FCRA registered entity to a non-FCRA registered entity. So yes, Aditya, the normal banking channel means the receipt of funds into your bank account, let's say via NEFT or an RTGS or an ECS or a check deposit. So those are the normal banking channels. So the main restriction that the government wants to put here is that there are no any cash deposits to the account.
Just to be mindful of the time, we're in the last couple of minutes of the webinar. So if there are any last questions, we'd be happy to address them. Otherwise, those can be taken offline as we suggested.
So Mercy, as long as your FCRA certificate is valid, so you need to file the nil statements with the ministry. So in case you have stopped receiving foreign funds and you will not be renewing your registration certificate, then that's when you will not be required to file as those statements.
In essence, Mercy, as long as the registration certificate is alive, you need to file the nil statements and the various other reporting requirements on a quarterly and annual basis. I think we're literally running out of time here, and I'm sure there might be still a lot more questions coming, but we do have to be respecting the time. And at the closer, we'd like to firstly thank all of you for taking out the time. And we see over 50 to 60 people who have been attending the webinar across the last 1 hour. So thank you so much for taking out the time. And we sincerely hope that we were able to address some of your doubts, if not all. We'd be more than happy to address queries offline, and you can write to us with our email addresses, which are mentioned on the screen, and we'd be more than happy to take forward any queries. We have offices across different locations in the country, so in case any of you are in any of these respective locations, feel free to drop in, and we'd be happy to address queries in person in addition to those which you might be sending over our way on email. Also, I'd like to thank my colleague Dhaval, who put forward this wonderful presentation and allowed for all of you to go over some of the insights, and most importantly to Gitika and the whole team at Atma for coordinating and putting all of this together. Thank you once again. It's been a proud privilege to be associated with the Atma network for the last so many years, and we'd be more than happy to continue our association. And thank you again to everyone for taking out the time and being with us this afternoon.
Thank you so much, Suhel. Thank you so much, Dhaval, for being here and actually doing this session for all our partner organizations. It was very informative and very helpful. Like you said, I'm sure that you've managed to address a lot of the questions that people have raised, and they can very well write to us. They can email either to Atma Network or to you directly with any specific questions they have, and I'm sure they will be addressed. By the end of the day, we will mail all attendees the presentation that you have seen today. We will also send you our feedback form. We request you again that you fill the feedback forms so that we are more aware of your requirements and we can take up topics that you would like us to cover in our future sessions. Until next time, that's goodbye from us.